Okay. May it please the court, my name is Lisa Hogrieve, and I'm the attorney for the appellant, Fred R. Bowerman. This action involves real property that's now owned by the Bowerman Trust, and it's located on the Indian River Lagoon in Brevard County, Florida. Situated on this land is a house and a 14-unit apartment building. In February 2004, the Bowermans and a Donald M. Dansby and/or a sign entered into a standard Florida Association Realtors commercial contract with an expiration date of June 17, 2004. The buyer chose Lawyers Title Insurance Company to act as the closing agent, and the buyer's realtor, by letter dated June 11, 2004, instructed the Bowermans to bring the leases and other documents relating to the leases to the closing, which had been set by the appellee to take place at its offices at 3 p.m. on the date the contract was to expire. What happened at closing is somewhat in dispute. Both sides have different factual scenarios as to what exactly happened at the closing and until 12 o'clock that night when the contract supposedly expired. Essentially, the Bowermans' claim, or now just Mr. Bowerman, his wife died, they were presented with a closing package, and he did bring with him to the closing his leases and the other documents that were required pursuant to the realtor's letter. But when they got to the deed had him transferring the property not to Dansby, but to a person called Robbie Roberts. The Bowermans were surprised by this and said, "Where is the assignment of Dansby to Roberts so I can sign this deed?" While they sat there, the closing agent looked through the file trying to find an assignment, left the room. Then the realtor came in. The realtor was, according to my client, went into a tirade saying, "You must close this deal. You're going to be in breach of the contract if you don't close this deal." The whole time my client maintaining, "Just show me the assignment. I can't do it without the assignment." He was calling it an affidavit in his deposition. Clearly he was referring to some kind of legal document that would show a transfer so he could legally transfer the property to the correct party. In the end, the title company could not locate the assignment that had evidently been signed quite a few weeks prior to. So there was that assignment that in fact was somewhere in the universe. It wasn't at the title company at the time of closing. Then the title company told the Bowermans, "Wait, Mr. Dansby is coming to the office and he's going to sign another assignment." My client asked, and they said, "He lives in Titusville, so it'll only take him 10 minutes, 5 or 10 minutes, because the closing office was in Titusville." My client said, "Well, where is he now? He might live in Titusville, but he might be in Miami now. Can you tell me where he is now so I know how long we're going to be waiting?" They could not tell him. At that point, he said, "You don't have the assignment. I can't close this deal as it stands now. I'm leaving." They got up and left. At some point, my client can't testify to it. The other side says that Mr. Dansby did come, and he executed another assignment on that date. Now, the law is that that assignment wouldn't be valid anyway, because that assignment, if Dansby had already assigned the property to Robbie Roberts now owns those rights. He can't go back and say, "Now I'm assigning rights that I no longer have," again to Robbie Roberts. Can't be done that way, and there's law on that. After this closing didn't take place, Robbie Roberts sued for specific performance and breach of contract. And Mr. Bowerman answered the complaint affirmative defenses, including waiver, filed a counterclaim, and a third-party complaint against lawyers, initially for kind of negligence, which they got dismissed, saying you can only have an indemnification claim as a third-party complaint. Restated it, this was a different attorney, restated it as an indemnification claim, and then lawyers' title came back and did a motion for summary judgment, which the court granted. Their argument and the arguments that the trial court accepted were, number one, that in common law indemnification, the underlying claim must be one sounding in tort and not in contract. And the trial court also ruled that Bowerman was not faultless, which is also required. Now, here are the items that the trial court found in order to determine that the Bowermans were not without fault. He didn't read the contract, because he admitted in his deposition that he didn't read the contract completely. He said, I only cared about who the parties were and what the amount of money I was going to get paid.
So the count against Bowerman that he was seeking indemnification for was brought exclusively in contract, is that correct?
Mr. Bowerman, because Robbie Roberts had sued him for breach of contract for not closing and hadn't also included as a defendant the liability that might have been on the part of lawyer's title, my client did a third-party complaint against lawyer's title saying, I might not have closed, but I didn't close because they didn't have the proper documents there for me to be able to close. And therefore, they are completely responsible for the failure of the closure, not myself. And so
the original claim was a claim exclusively for breach of contract, correct?
And yes, and specific performance, which is an equitable remedy.
Bowerman's claim over against lawyer's title was for indemnification if he's liable on that breach of contract count, correct?
When you're saying that in the indemnification, I'm saying he's liable on the contract count.
No, well,
he's liable for any damages that my client might have to pay.
The nature of indemnification is if I'm liable to the original plaintiff, you're liable to me, right?
You're liable for my damages that I have.
Part of the proof of the indemnification claim is I'm liable to the plaintiff, correct?
Exactly, and that was never
determined. Which is that I am in breach of the contract,
exactly.
Correct? Was there evidence in the record that your client was in breach of the contract?
There was some evidence, but that's all a factual issue that can't be determined prior to an actual trial on those issues. So there's case law, and
What was the evidence that your client was in breach of contract in light of his argument that I had no obligation to close because there wasn't an assignment and therefore I didn't have to?
Here was the evidence, and it's pretty much set out in the trial court's order granting summary judgment. He didn't read the contract. Completely irrelevant. You cannot read the contract and completely perform the contract and every obligation in there and not be in breach. So reading the contract has nothing to do with it. Then the second item was he didn't send written closing instructions, as was his responsibility, to the closing agent.
Are these items that the trial court found put him in breach, or are these items that the trial court used to say he wasn't faultless?
That he was not that he was not without fault.
Okay, I was asking you what evidence there was to establish that he was in breach of the contract.
From all I can tell is the things that they said were that he had some fault. They didn't really make a determination on who was in breach, although in a contract case, you can be breaching minor provisions that have been waived. You can do a lot of things, but you would eventually prevail in the lawsuit. So without determining the end result, who's going to prevail in the contract case, you can't say who is without fault.
Well, let me ask you this. In the specific performance action between your client and the buyer, isn't the primary issue whether, given the lack of an assignment being present at that moment of closing, your client had a right to leave and not close?
He absolutely had a right to leave.
I mean, isn't that the issue?
It's like a prior,
Right, but isn't that the issue?
yes.
All right. And if your client had the right to leave because of the lack of an assignment, we don't have to worry about the third-party action because it's a zero verdict against your client or a finding in favor of your client. Right?
It does make a difference. Okay.
Well, what liability, if your client's not liable, what liability is there from the title company to your client?
Well, the problem is with the court making the summary judgment determination on the indemnification action prior to knowing who is actually in breach and if my client's going to be responsible at all, there's definitely going to be a claim for attorney's fees because he's prevailed in his motion for summary judgment when he really shouldn't have prevailed in the motion for summary judgment, or our cause would never have come forward at that time. Whether he is liable to indemnify us, whether we prevail or not, is different. If we do not prevail because my client is at fault, then they have a possibility for attorney's fees.
But if your client did not have a right to leave under those circumstances and therefore loses the specific performance action, is your client faultless?
Not if the court ultimately determines that my client breached the contract because he did not have a right to leave. But there's a situation where both parties, both the buyer and the seller, are faultless. And the blame is completely on lawyer's title. But in that case, the judge is going to have to determine that the plaintiff does need to recover. Even though my client is faultless, the plaintiff needs to recover because it's not the plaintiff's fault either.
What's the scenario that would establish that your client breached the contract, but he was faultless?
What's the scenario? That he breached items that, well, let's say that the plaintiff breached provisions prior to the time, so they were first in breach. Because all the breaches that they're talking about are very minor, like he didn't give written instructions to the closing agent, which we claim were waived because the buyer and the realtor had made all the arrangements with the closing company. And even if my client had made written instructions, it wouldn't have changed anything.
But those are factors that went to your client's fault, not to his breach, which are two different things.
Well, how can, if there's a breach that wouldn't, or if there's a actual obligation that my client didn't perform, and he didn't perform it because somebody else had taken over that obligation, does that make him, is that a fault of his? I don't think that can be a fault. Somebody else is saying, I'm doing it, you don't have to do it, but we're going to come back later and now say you were at fault because you didn't do it. Or the other side breaches first. My client wouldn't be obligated to perform after that.
Then it's not a breach. If there's a prior breach by the other side, then that's not our scenario of your client breached, right? Because the prior breach releases your client.
Exactly, but you're saying there's a difference between being legally found to have breached the contract versus being at fault. And I don't know if there's a big distinction, because if you're ultimately found to have not breached the contract, then all those little things that you said were breaches and at fault, I think they disappear. Because there are reasons that ultimately you're found not to be at fault.
Well, what we're talking about is a material breach on the part of your client that would lead the plaintiff to recover.
I don't think there are any. When you look at
Well, there may not be factually, but the legal issue here is whether there is a third-party complaint for indemnification that will survive a legal challenge. So you begin with the proposition, as the other judges have already pointed out, you begin with the proposition that your client is liable for breach of contract. You have to start there, because if he's not liable, then the case goes away.
That's why you usually wait.
So, well, you may not have to wait if, as a matter of law, there's no liability. And that's what the trial court said. The trial court said you don't have a right of indemnification against against lawyer's title in this case?
Because they had two bases. Because my client wasn't faultless, how do they determine that when they haven't looked at the waiver issues or who breached first or any of those factual issues?
Well, as a matter of law, he has to have materially breached the contract in order to have the conversation. You can't start the conversation without the assumption that your client was in material breach of the contract. So then the question becomes whether, given the fact that he materially breached the contract, i.e. he had no right to refuse to close, whether he can claim that liability over against the title company. And the trial judge said no. As a matter of law, he doesn't have that right because he was in breach.
If you look at the case of the State of Florida Department of Transportation versus Bell South, that's a contractual issue. And the fact that...
but there's no allegation of a contractual relationship here between your client and lawyer's title.
But I don't think there was in DOT either. The actual contract...
Those were implied warranty cases where someone who is a seller of a defective product has a right over against the supplier to the seller.
I don't think the Department
because
of DOT...
there is a contractual relationship. I bought it from you in its defective state, and now I am being held liable solely because I sold it to them. It's not the same thing.
DOT was not a warranty issue. That was a breach of contract issue between a contractor...
But it involved a direct contractual relationship between the parties. They had a contract with Bell South, and they had a contract with the contractor, and that was the issue among the contracting parties. That's not what you have here. What you have here is a situation where we have to assume as a matter of law that your client breached the contract, that he failed to do what he had a legal duty to do. And then the issue becomes whether he has a right to say, well, if I screwed up because lawyer's title didn't do what they were supposed to do. That's your theory, isn't it?
My theory is that my client did not close. He did walk out. I don't think he was wrong in walking out because he could not sign those documents. But if technically the court wants to find that, well, the plaintiff didn't do anything wrong, it was really the title company that made the mistake, you got to look at who's going to bear the damages in this case. Should it be two parties that really didn't do anything wrong, or the party that did the documents and is ultimately to blame? I think technically the court's going to have to say at one point either the plaintiff's going to prevail in the breach of contract or my client is, whether they're going to say my client was at fault. I mean, you have to say you're technically at fault at some point if you're going to have indemnification.
Either your client breached this contract or he didn't. If he did breach the contract, then he can have no right of indemnification against lawyer's title.
Well, from this theory, from what you're saying, there's only two outcomes. There's no indemnification because if my client prevails, he doesn't have damages and there's no indemnification. If he doesn't prevail, he doesn't have damages and there's no indemnification. So what happened to common law indemnification?
Maybe that's why it only
went away.
applies in torts.
Okay, but I have case law that shows that it's not just for tort. But if you look
But those are contractual relationships, and there is no contractual relationship here. Your client alleges that lawyer's title made me breach this contract.
They did.
Well, but that doesn't give them a right. It doesn't give him a right of indemnification. He may have a right to damages, assuming he can state a regular cause of action. But
that was not allowed.
He hasn't done that. All he said was, even if I breach the contract, then you have to pay me back because I am only technically liable because of your breach. But that can't be possible in a case where, as a matter of law, he's breached the contract.
Well, how do you reconcile that with the 4th DCA case of Orange-Jetski, where it's almost the same scenario. There was a buyer, a seller, and a realtor. And actually, the trial court decided who...
I've read all of these cases. I've found no case that stands for the proposition that if somebody, that there can be liability in a situation like this. Indemnity only applies to someone who is technically liable because of an act of another. In this case, your client can't be technically liable because of the act of another. He's either breached the contract or he hasn't.
We tried, or the prior counsel did bring a cause of action stating just what you're saying. It's not going to be indemnification, but it's, okay, I didn't close, I'm not at fault, it's all your fault. And the trial court, and they came with the rule from the Florida Rules of Civil Procedure that a third-party complaint can only be an indemnification. So my client's between a rock and a hard place saying that
if your client can manufacture a cause of action out of his breach of contract against lawyer's title, then there's no reason why he can't pursue it. But he can't do with indemnification what he can't do under the law otherwise.
Well, with all due respect, Your Honor, I think that the Orange-Jetski case is this case. It doesn't involve a direct contract where there would be contractual indemnification, and there are other cases that I cited that are not a direct contract between the person that you're seeking indemnification and the third-party plaintiff, if you will. And I would also say that my client did have an Ortez motion to amend, which was not really denied or granted. It kind of just got swept under the rug.
You're well over your time.
I understand.
I will give you 1 minute for rebuttal.
Thank you very much.
Good morning. May it please the court, my name's Brad Luzak, and I'm appearing today for Lawyers Title Insurance Corporation. I think the place where I would like to start, with y'all's permission, is with a demonstrative aid to try to help sort out the only two scenarios or possible outcomes question, and where did the common law indemnification go to. This may be unusual, but may I approach the bench with bench copies of the demonstrative aid?
Has opposing counsel seen him? I don't have any
problem with that.
It's usually a better practice to file a motion and get it put on something really big so we can see it from a distance.
And frankly, I should have done so, but I think it will certainly help in the analytical process if you'd prefer I do it without.
Why don't you just do it from there?
Yes, ma'am. When we're dealing with common law indemnification, there are two variables. The first is, does the defendant have liability to the plaintiff? And the second is whether or not the defendant has fault. As to each of those two variables, there are two possible outcomes. In other words, either the defendant has liability to the plaintiff or the defendant does not, and either the defendant has fault or it does not. So there's really not just two scenarios here, there's four. Under one of the four scenarios, the third-party defendant has liability under common law indemnification. Under the other three, it does not. The only scenario under which a third-party defendant has liability for common law indemnification is where the defendant has liability to the plaintiff and the defendant does not have fault. where the defendant has no liability to the plaintiff, there cannot be actionable claim for common law indemnification. Likewise, where the defendant has fault, there cannot be actionable common law indemnification. Here, what the trial court did, as Judge Griffins noted, is assumed for the sake of argument that the defendant, Mr. Bowerman, breached the contract and then looked at, well, Mr. Bowerman, if you breached the contract, do you then have fault? And determined that there was plenty of fault based on the undisputed facts. There's really not much of an issue of fault once you've assumed that there is a breach of contract, since Mr. Bowerman did not perform many of his obligations under the contract for sale and purchase, as specifically noted by the trial court in its findings of fact. So I just wanted to clarify, to bring this around, and again, the matrix makes it more visually understandable, that there are 4 scenarios that are possible, but only one under which there's potential liability, and that's where the defendant both has liability to the plaintiff and the defendant has no fault. In the case at hand, the defendant had fault if there was a breach of contract. Therefore, it was appropriate for the court to enter a summary judgment on the common law indemnification claim, and the trial court did not have to wait until the underlying breach of contract claim was determined.
How is this case different from this Orjeszewski case out of the 4?
It's different in several respects. And I can't pronounce the first name, but the case that you referred to did not turn on the fault issue, but rather that case, the summary judgment was granted to the third-party defendant or defendants on the liability issue. And as I recall what occurred in that particular case, the plaintiff moved for summary judgment on his underlying claim and for breach of contract, and the court entered what I assume was a partial summary judgment, reserving for trial the defendant's affirmative defenses to the breach of contract claim. There isn't a lot of discussion about how that worked, and frankly, I have difficulty conceiving of how it worked. But with that said, there appears to have been a partial summary judgment in favor of the plaintiff, and the court said, okay, because there's no liability here, one of the 2 variables is missing, therefore we don't have to get to the question of fault. The third-party defendants can't have liability, and granted a summary judgment. The problem with what that trial court did is the issue of liability had not been conclusively determined at that point. And once they went to trial, the affirmative defenses were tried, and apparently the defendant prevailed on those affirmative defenses. That's what I understood happened in that case. That's why that case is completely distinguishable, because it turned on the issue on the first variable, the liability of the defendant to the plaintiff, did not turn on the second, fault, and it was not appropriate for a summary judgment on the first issue, the liability of the defendant to the plaintiff. It really doesn't control the case whose name I can't pronounce, doesn't control this case at all, and is factually distinguishable.
Is the main claim against Baumann still pending in this?
It is. It doesn't appear anything's happened in the last several years on that. I welcome any questions the court may have for me.
Well, I guess the problem that the appellant is having is, why is it that as a matter of law, your client isn't liable under the scenario where it was your client's negligence in failing to provide the documentation that was necessary for a timely closing that resulted in Mr. Bowerman refusing to close?
Great question. It makes an assumption, however, and that assumption is that it was my client's duty to provide the documents.
Well, let's assume that
Well, I
is
know.
the duty.
Well, let's just make that assumption.
Well, before we make...
If we, just as we're making the assumption that Mr. Bowerman is liable in breach of contract as a matter of law,
But-
if that's true, if it was your client that failed to provide the documentation, you got to be earning those fees for doing something. If you got a contract that says that the property's being sold to Soldier A, and yet you're doing a closing where it's being sold to Soldier B, I mean, just as a matter of common sense, you'd think that somebody would have an assignment in the file, and they didn't.
Time out, if I may, Your Honor. The assumption you're making that they didn't have a copy of the assignment in the file is not borne out by the record. What is borne out by the record is that the closing agent was not able to get the assignment and provide it to Mr. Bowerman within the very short period of time, approximately 5 minutes, that Mr. Bowerman was there and before he stormed out.
But assume,
Okay.
just go ahead and
Yes.
assume that the title company had a duty to procure the assignment, and assume that for whatever reason, someone forgot to make a phone call or whatever, they didn't do it. So these people show up at closing, and the seller wants to see the assignment, and it's not there because of your client's negligence, failure to perform a duty, etc. Is there a basis for indemnity in that situation, or does your client walk away scot-free if they screwed up, or what's the law in that scenario?
The law in that scenario, I believe, is that a closing agent may be held liable for negligence where there's a duty and that duty is breached. Whether that negligence claim may be asserted as a third-party claim is a separate and distinct issue, but there's no doubt that under the law in the state of Florida, a closing agent may be held liable for its negligence, if in fact it's negligent. Let me go back to the...
Yeah, I think the question is, but can they be held liable in an indemnification action like the one brought here?
No.
And why not?
And that's a great question. The "and why not" is, well, that's a qualified no. They cannot, under common law indemnification, if that's the variety of indemnification we're talking about, as distinguished from contractual indemnity or indemnity implied in fact, which is kind of an offshoot of contractual indemnity. But if what we're talking about is common law indemnity, the answer to why is common law indemnity is a principle of law that was or a doctrine of law that's intended to deal with the unfairness of the application of joint and several liability with joint tortfeasors. In a breach of contract action, it simply doesn't have any application. Where the underlying cause of action is for breach of contract, it doesn't have any application. There certainly could be, and this is the other half of the qualified answer, there certainly could be liability for contractual indemnification and a third-party action if such a contract existed, none exists in the facts at hand. I feel compelled to come back to the hypothetical or the assumption that it was the duty of the closing agent to provide the documents. It was not.
Don't bother.
Okay.
Don't bother. The only thing we're concerned about is whether it's possible for indemnification to exist here.
And I suggest it is common law indemnification cannot. Other varieties of indemnification, express contract, implied contract could. Any other questions? Then I thank you very much. You all have a great day.
Do I have 2 minutes of rebuttal here?
No, you're already 2 minutes over your time.
Oh,
so
okay.
So you've got till it hits 3 minutes.
Okay. I would like to address something that Justice Griffin had talked about, were the findings that the court made as to fault versus breach. Did she make fault determinations that could possibly cause the motion for summary judgment to be entered properly? And my question is, can you decide fault? Does the fault that's determined, does it not need causation? If somebody's at fault, does the fault have to relate directly to have caused the breach? And I would say yes. So even if the judge said you were at fault because you ran a stop sign on the way to the closing, that didn't cause the closing not to close. And I think the things that were found in the summary judgment order were items of fault that were not significant and were not the cause of the closing not to happen.
That's your time. Thank you, counsel.
I would just say that all the case law for opponent came out of state, so if there is no common law indemnification, I wonder why there are no Florida cases that are cited in this brief.
Thank you, counsel.